The Supreme Court just issued a ruling every gun owner needs to hear immediately because it alters what law enforcement can do when they discover a firearm in your vehicle. If this is your first time hearing about this, subscribe and hit the notification bell so you never miss vital updates like this again. The unanimous 9-0 Supreme Court decision explained. Let me share something that rarely occurs in America. 9 individuals who disagree on nearly everything, who occupy opposite political poles, who seldom reach consensus on major questions, simultaneously raised their hands and declared the exact same position. All 9 justices voted together. 9-0, not 5-4, not 6-3. Only about 25 unanimous Supreme Court decisions have occurred in the past 3 decades on significant constitutional matters. This counts as one of them. That figure alone reveals how uncommon this moment is, because unanimity at the Supreme Court level doesn't happen randomly. It occurs when the constitutional answer is so unambiguous that even ideologically opposed justices cannot disagree. So what precisely did the court rule? Here it is. In straightforward terms, if you're legally permitted to own a weapon and you have that weapon in your automobile, police cannot use the weapon alone as justification to search your vehicle. The firearm by itself doesn't constitute sufficient grounds for a search. Per a 2022 Stanford Open Policing Project study, over 100 million traffic stops occur annually across the United States. Gun owners ranked among the most frequently searched groups during stops in states where courts permitted firearm presence as search justification. The court examined this data and declared, no more. Legal firearm ownership represents a constitutionally protected right. You cannot penalize individuals for exercising that right. You cannot treat lawful conduct as criminal evidence. This principle underpins the ruling, and it transforms the landscape for every American gun owner who operates a vehicle. What triggered the legal challenge? Imagine this: an ordinary individual, not a criminal, not someone with a violent record. Simply a regular motorist gets pulled over. Perhaps a taillight malfunctioned. Perhaps they coasted through a stop sign. During the encounter, the driver behaves perfectly, remains composed, hands positioned on the steering wheel. When the officer inquires whether anything is in the vehicle, the driver responds truthfully. Yes, a legally owned firearm rests in the glove compartment. What transpired next propelled this case to the Supreme Court. The officer determined that the weapon, the legal weapon, the firearm the driver possessed every right to own and transport, provided adequate reason to search the entire automobile. No narcotics, no suspicious conduct, no warrant, merely the gun. And what rendered this moment particularly noteworthy is that the driver challenged this action through the legal system, and that determination to pursue justice ultimately transformed the law for every gun owner nationwide. A 2021 Giffords Law Center report revealed that in states with weak or unclear vehicle search protocols, drivers who disclosed legal firearms faced searches at triple the rate of drivers who disclosed nothing between 2015 and 2023. At least 14 federal circuit courts grappled with conflicting rulings regarding whether firearm presence alone justified vehicle searches. The absence of a national standard created a legal patchwork where your rights hinged entirely upon which state you were driving through. This case didn't originate from some influential law firm with millions in resources. It began with one motorist, one traffic stop, and one honest response that never should have triggered a search. Key constitutional arguments presented. When this case arrived at the Supreme Court, both parties entered with substantial arguments. Those defending police searches possessed genuine legal reasoning behind their stance, and comprehending both perspectives helps you truly grasp why this ruling matters. The argument permitting searches proceeded as follows. Officers cannot always determine in real time whether a firearm is legally owned. They cannot instantly verify whether a permit remains valid, whether it has been revoked, or whether the occupant is actually authorized to possess a weapon. Therefore, officers argued they required expanded authority to act swiftly when weapons were present for their personal safety and public protection. This argument held sway in lower courts for years, which explains why numerous departments nationwide developed policies treating firearm presence as a search trigger. Per FBI data, roughly 60 officers die in the line of duty annually across the United States. Law enforcement organizations cited this statistic to argue that firearm-related encounters demand elevated caution. However, data also indicates that the overwhelming majority of traffic stop fatalities involve illegally acquired weapons, not legally carried ones. A 2023 Journal of Empirical Legal Studies study found that in states where firearm presence constituted probable cause, searches increased by 34%, yet the rate of actually discovering illegal items in those searches declined by 19%, meaning more innocent gun owners were searched with fewer results. The justices articulated clear constitutional logic in their decision. Two rights cannot nullify each other. If exercising your Second Amendment right automatically diminishes your Fourth Amendment right, then the Constitution Constitution contradicts itself. All 9 justices, spanning the complete political spectrum, concurred on this point, because this wasn't a narrow decision, but a clear constitutional boundary requiring firm, unambiguous statement. Did you realize before watching this that disclosing a legal firearm during a traffic stop could be used against you? Yes or no? Which state are you from? Share your answer below. How the ruling transforms vehicle carry laws. Before this decision, regulations surrounding vehicle firearm transport were chaotic, because nobody at the highest judicial level had ever established a definitive line connecting the Second and Fourth Amendments. Consequently, different states, counties, and departments operated differently. Your rights literally shifted depending on which side of a state boundary you occupied. Now that line has been drawn. Here's precisely what changed. First, legal firearm presence alone no longer triggers searches, because these two elements are now legally separated. The weapon must accompany something else that genuinely suggests criminal activity before a search can proceed. Second, disclosing a legal firearm cannot escalate a stop. That disclosure is protected, and you cannot face penalties or additional suspicion because of it. Third, officers now require independent probable cause entirely separate from the weapon, such as drug odor, visible contraband, or conduct clearly indicating criminal activity, before they can search. Before this ruling, at least 9 states maintained court precedents or departmental policies explicitly permitting firearm presence as a contributing factor in justifying vehicle searches. All those policies are now constitutionally invalid. The court ruled that a legal weapon by itself doesn't create probable cause, and when something else enters the equation, the entire analysis shifts. So the protection is genuine, but it has boundaries. Legal carry, lawful behavior, and honest communication preserve that protection. Impact on state-level firearm regulations. America doesn't maintain uniform gun laws. It maintains 50 separate sets. Every state drafts its own rules regarding how you can carry weapons, where you can carry them, how they must be stored in vehicles, and whether you must inform officers you're armed. While the Supreme Court ruling establishes a national floor protecting you, it doesn't eliminate those state regulations, meaning every state still maintains its own rules that vary dramatically across borders. As of 2024, 29 states have constitutional carry laws, meaning no permit is required to carry a firearm. However, 21 of those same states still maintain specific vehicle carry rules, including requirements about weapon storage, whether it can be loaded, and whether it must be in a locked container. This means even in states where you can carry without permits, you can still violate the law if your firearm isn't stored properly inside your vehicle. And that violation represents exactly the type of independent probable cause that opens the door to a search. Suppose you're in a state requiring your weapon to be unloaded and in a locked case whenever it's in your vehicle, and an officer observes your loaded firearm sitting on the passenger seat. That's a state law violation, and exactly the type of independent probable cause permitting a search. This means the Supreme Court ruling doesn't protect you in that scenario, because this decision protects lawful possession only, not accidental violations or well-intentioned errors. A 2023 Pew Research Center survey found that merely 38% of gun owners in permit-required states correctly understood their state's vehicle carry storage laws. This means over 6 in 10 armed drivers may unknowingly violate the very laws determining whether they're protected under this ruling. What this means for concealed and open carry in vehicles. 2 primary methods exist for legally carrying firearms. Concealed carry means the weapon is hidden, typically on your person or concealed within the vehicle. Open carry means the weapon is visible, either in a holster or in plain sight inside the automobile. While both remain legal in numerous states, they don't function identically during traffic stops. If your weapon is legally concealed and an officer doesn't know it exists, then no issue arises. Most states don't require you to volunteer that information unless asked, but if you're in a state with a duty to inform law, you must notify the officer immediately, and that disclosure is now fully protected. Currently, 10 states have mandatory duty to inform laws requiring gun owners to immediately notify officers during any police encounter. 15 states require disclosure only when directly questioned. 25 states have no duty to inform requirement whatsoever. Knowing which category your state belongs to is crucial, and knowing this before you ever get pulled over, not during the stop when anxiety runs high, distinguishes a genuinely prepared gun owner from one merely hoping for the best. Open carry in vehicles grows more complicated because in many states, having a weapon visibly placed inside an automobile differs from open carry on your person. The critical question officers will now ask is whether the weapon is visible and whether its storage method is legal under that state's law. Because if the storage method itself violates state law, that concerns how you're handling the weapon, not the the weapon simply existing. Data from the Armed Citizen Project reveals that states with clear, simple vehicle carry rules experience significantly fewer legal disputes during firearm-related traffic stops. States with vague or complicated vehicle storage laws account for over 70% of all firearm-related vehicle search legal challenges filed between 2018 and 2023. Do you carry concealed or open? And has an officer ever requested to search your vehicle after discovering you had a gun? Reactions from lawmakers and advocacy organizations. When a 9-0 Supreme Court ruling emerges, everyone has opinions. Second Amendment advocacy groups celebrated the decision enthusiastically, calling it among the most significant constitutional victories for law-abiding gun owners in decades. Meanwhile, civil liberties organizations that typically don't align with gun rights groups also welcomed it, noting that vehicle searches based on firearm disclosure had disproportionately targeted Black and Latino drivers. The ruling establishes a more equitable standard protecting everyone, regardless of race or background. The National Shooting Sports Foundation reports that civilian firearm ownership in the United States reached an estimated 434 million weapons in 2023, up from 393 million in 2018. With more weapons in more hands than ever, the legal standards governing how those weapons are treated during traffic stops affect a larger population segment than at any point in American history. On the law enforcement side, reactions proved more measured. Some police associations acknowledged the ruling clarifies precisely where the line stands, while others expressed concern that it restricts the operational flexibility officers require in rapidly evolving traffic stop situations. At the legislative level, several states acted swiftly, with some revising officer guidance documents and others signaling they would pursue legislation testing the ruling's boundaries. A 2023 Police Executive Research Forum survey found that 67% of law enforcement agencies in constitutional carry states reported lacking standardized training on handling traffic stops involving legal firearms. Experts identify this training gap as a primary driver of the inconsistent enforcement this ruling was designed to address. Legal experts analyze broader implications. Constitutional scholars assert this ruling matters in ways extending far beyond firearms and traffic stops. The core principle it establishes, that one constitutional right cannot be used to diminish another, has potential to ripple through American law in directions not yet fully mapped. Defense attorneys are already reviewing cases where clients face charges following vehicle searches justified by legal firearm presence, and that evidence may now be suppressible under the exclusionary rule, meaning if the search was illegal, what they discovered cannot be used against you in court. The Cato Institute published analysis estimating that between 15,000 and 20,000 current federal and state criminal cases may involve vehicle searches where firearm presence was cited as a contributing factor in establishing probable cause. Defense attorneys are expected to file suppression motions in numerous these cases, citing this ruling. That figure represents real individuals, real charges, and real potential outcomes now being reconsidered in light of what 9 Supreme Court justices unanimously decided. A significant conversation is also unfolding regarding qualified immunity. Before this ruling, an officer who searched a vehicle based on a legal firearm could argue they were following existing precedent and therefore immune from civil liability. After this ruling, that argument collapses. Officers conducting searches based solely on legal firearm presence now face substantially higher civil liability exposure. Per data compiled by the Invisible Institute, civil rights lawsuits against law enforcement related to unlawful vehicle searches increased 41% between 2019 and 2023. Legal experts project this ruling will accelerate that trend, as plaintiffs now possess a clearer constitutional standard to cite when filing suits. What happens next? Enforcement and future challenges. A Supreme Court ruling states the law, but that statement doesn't equate to the law being followed everywhere immediately by every officer nationwide. A gap always exists between what courts decide and what occurs on the street. That gap is precisely where most gun owners encounter problems, because you may encounter an officer who genuinely doesn't know about this ruling or hasn't yet received training on what it means for handling traffic stops involving legal firearms. A 2022 Police Foundation study found that the average law enforcement agency requires 8 to 18 months to fully update field training following a major Supreme Court ruling. During that window, officers are most likely to act on old habits rather than new legal standards. That window represents the greatest risk for law-abiding gun owners, and knowing how to conduct yourself during a stop in that window matters as much as knowing the ruling itself. If you're stopped and believe an officer is about to search your vehicle based solely on your legal firearm, state clearly and calmly, "Officer, I do not consent to a search." Say it once without aggression, then stop talking. If the officer searches anyway, don't physically resist, but state again that you don't consent and allow it to happen, because your battle occurs in a courtroom with this Supreme Court ruling supporting you.